Domestic violence is one of the most common crimes in the United Kingdom, but it is also one of the most underreported. Within this presentation, I will delve into the role of specialised domestic violence courts, their history, prevalence, and their importance in modern society, as to allow the victims of these crimes to report the atrocities which have befallen them in a safe and controlled environment. Firstly, let's explore some facts about domestic violence as to provide some background to the topic. It can be seen that an estimated 2 million adults aged 16 to 59 experienced domestic abuse in the year ending March 2018, equating roughly 6 in 100 adults. It can also be seen that women were twice as likely to have experienced domestic abuse compared to men, with the figures showing 1.3 million female victims and at 0.7 million male victims. Around 1 in 5 children have also been exposed to domestic violence, and because of this, children exposed to domestic abuse are much more likely to develop behavioural and emotional problems further down the line during their development. Based on these statistics, it can be determined that domestic violence cases are incredibly prevalent in modern day society. So what is being done about it? Unfortunately, there is no specific law in which encompasses the entirety of domestic violence, as all crimes are registered under their own specific laws, such as extortion, physical harm, etc. This allows for charging based on certain crimes to be more streamlined and reflect the severity of the crimes committed. In 2015, however, the sentencing guidelines implemented a new offence, with the overall purpose being for domestic violence cases, known as Section 76 of the Serious Crimes Act of 2015. With the core focus being on cases of controlling and coercive behaviour by intimate relations or familial members, whether they're siblings, parents, step-parents, grandparents, or any other kind of close family relationship. This is a great step in the right direction, but what else is being done? Well, this is where we can explore the realm of specialised domestic violence courts. Domestic violence doesn't have a legal definition, but the more common working definition can be considered as any incident or pattern of incidents of controlling, coercive, or threatening behaviour, violence, or abuse between those aged 16 or over who have been intimate partners or family members, regardless of their gender or sexuality. This can encompass, but is not limited to, the following types of abuse: psychological, physical, sexual, financial, and emotional. So what exactly are specialised domestic violence courts? Well, they are a variation of the magistrates' courts, in which aim to limit the exposure of the victim to their abuser, and to make the process as easy as possible for the victims in an attempt to allow them to have a less fearful time coming forward, as to make sure that they safely address issues they face, while also ensuring that more successful outcomes are occurring with domestic violence cases. More information on the process can be seen shortly, but first let's explore the history of these courts and their implementation across the United Kingdom. In 1976, the issue of specialist domestic violence courts first became prevalent to Parliament when, following a select committee report, Joe Richardson MP gained backing for a private member's bill as to allow the right to apply for a family court for a protective order. Within the 1999 Labour government, however, the effort was made to tackle domestic violence even more so, by attempting to follow the models in which other countries, such as the US and Canada, had set, which in turn led to the implementation of specialist domestic violence courts model, which was originally tested across multiple areas in the country over a 5-year period, as to ensure that their successfulness before being implemented nationally. Fortunately, the evaluations of effectiveness were incredibly positive, and these types of courts were rolled out nationwide in 2005 to 2006. As of 2013, it can be considered that there were 138 courts of this type. Once these specialist domestic violence courts were implemented, 2 further initiatives were sought, namely the independent domestic violence advocate, with the main purpose of addressing the safety of victims at high risk of harm from intimate partners, ex-partners, or family members, and to secure their safety and the safety of their children. In addition to this, there was also the Multi-Agency Risk Assessment Conference, which is a victim-focused information sharing and risk management meeting attended by all key agencies, where high-risk cases are discussed and evaluated. The role of the Multi-Agency Risk Assessment Conference is to facilitate, monitor, and evaluate effective information sharing to enable appropriate actions that are to be taken to increase public safety. As expected, specialised domestic violence courts maintain certain procedures and freedoms as to ensure that the victims maintain the easiest transition through the process as possible. Some of the means in which this can occur are specially trained court personnel, specially trained prosecutors and police who have good awareness of key features around domestic abuse, thus ensuring that they can proceed with the utmost care around the victim. There's also special preventative interaction measures, which are put in place to maintain that victims do not have the opportunity to come into contact with their abusers, through means such as separate entrances and exits, waiting areas, and many more. There is also tailored support and advice for victims, which can also come through the means of the Independent Advocacy Program, as mentioned earlier. There are also specialized children's services and community-based perpetrator programs available. Now that we have some background on the courts themselves to understand their purpose and why they've been implemented, we can examine the process of these courts. Once a complaint comes through from a victim, it is sent for a specialised domestic violence court, which is a magistrate's court which has been specially set up to ensure the parameters of the victim's safety are ensured. Then, one of two routes is followed. If the defendant pleads guilty, then a sentencing hearing occurs immediately after the plea in the majority of cases. Although there are other cases in which sentencing is delayed, as to ensure that the sentencing committee can receive as much information as possible to provide more context as to enforce a more accurate sentence on the defendant. The other route in which may be followed is that of a not guilty plea. If this magistrate's court believe that the crime is too severe for them to handle, they can defer it to the Crown Court for sentencing there. If this is not the case, however, then a preliminary hearing is set and the case is adjourned out of the Specialist Domestic Violence Court and is tried in the normal magistrate's court. In some instances, it may be adjourned from the normal magistrate's court upon a verdict back to the Specialised Domestic Violence Court due to their deeper understanding of domestic abuse issues. So, why exactly are they used? Well, there are a variety of different reasons in which are common. The most likely one, however, is to ensure the safety of the victims and children. Ensuring that a victim doesn't have to come face to face with their abuser, when you can consider the coercive nature of some of the instances of domestic abuse, it will allow for the victims to be able to ensure a clearer recollection of events and provide a more detailed and accurate report. One of the most standout issues with courts in the modern system is the lack of information for the victims. Specialised domestic violence courts ensure that victims maintain and are kept up to date with all of the proceeds of the court as to ensure their well-being. It can also be seen that Women's Aid believe that only between 1/5 and a quarter of domestic abuse matters ever actually get reported to the authorities. And it is the hope that with further exposure and more knowledge of these types of courts being in existence and the services in which they provide, that this number will increase in the near future, given that the domestic abuse figures mentioned at the beginning of the presentation are the highest in the country's history. It is incredibly important that initiatives are set out as to ensure that this number is reduced in the future. As mentioned previously, there is no specific crime for domestic abuse, but there is a set of guidelines in which was implemented under Section 76 of the Serious Crimes Act of 2015, detailing the nature of certain crimes which are of controlling and coercive nature by family members or intimate relationships may come under this clause. Sentencing is based upon severity of the crime and the outlining of these guides, but there are also a variety of different aggravating and mitigating factors which may increase or decrease the severity of the sentencing. These mitigating factors which may be considered could be the evidence of genuine recognition that the person needs to change, and evidence that they may be getting treatment to help this change, such as through the means of behavioural therapy. There's also a mitigating factor of positive good character, which could be testimonies on character by friends and family, personal history, and many others. The aggravating factors, on the other hand, may include the abuse of trust or power, which is incredibly common in a domestic context, where the defendant is in a trusting relationship with the victim, but has been abusing it and seeking to control them, which links back to the coercive nature of the crime. Another aggravating factor may be any vulnerability which the victim may have, which makes it impossible for the victim to leave, whether that be physical or mental disability. There's also the issue of exposing children to the offence, either indirectly or directly, which, as previously mentioned, can lead to developmental issues further down the road for the children. And finally, a proven history of violence and threats, which in turn can provide evidence for the defendant's character, especially if shown over a long period of time, can lead to further evidence that the person in question, the defendant, is of an unfavourable nature and needs to be sentenced accordingly. It can be seen that, in conclusion, that these types of courts are incredibly important as to ensure that the victims are protected and the defendants are treated accordingly based on the severity of the crime. And there is the utmost importance that they maintain their functionality as to ensure that future cases of domestic violence can be handled with the utmost care by the professionals in their fields.